Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Me and my teammate represent about discharge of contract. So we start off with the definition. Discharge. The word discharge means coming out. So by considering it, we can say that quitting from a contract is known as discharge of contract. That means two or more parties set a contract by forming a certain rules and regulation with the acceptance of both parties, and they need to obey the rules and regulation. Then the contract will be in the condition of discharge. Next, discharge of contract. The discharge of contract is defined as termination of an contract or an agreement made by two parties with the fail in performing the obligation mentioned at the time of creating an agreement with the acceptance of both parties, right, free of consent. Hence, the obligation may be contractual or legal or operational or even by performance itself. So, it is important to understand the method of discharge of a contract. There is a lot of method, and the first one is discharge of contract by performance. This means that the discharge of contract occurs when both parties are refused to perform the obligation can be referred to as discharge by performance. That's all from me. We will continue the presentation onto the next presenter. Thank you very much.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Akib Jamsuddin. Now I will talk about the discharge of contract by agreement. The terms agreement and contract are used interchangeably, but legally speaking, there are two different things. An agreement is simply an understanding or arrangement between two or more parties. A contract is a specific agreement with terms and conditions that are enforceable court. In this discharge of contract by agreement, if either of the person in the contract is not willing to continue the contract till you date, then it is converted to the other party, whether they may accept or not. The discharge of the contract by the agreement will happen, but it occurs in various situations. Like they are: firstly, novation. Innovation either specify the situations of a new contract in the place of the original contract, or new members in the place of one, whether it may be a single person or both the party. It is known as novation, which is a part of the discharge of contract by situation of agreement. The second is rescission. Here, both the parties agree to modify certain rules and regulations in the contract with mutual understanding. It may lead to the cancellation of all the rules or may cancel partially. Now we move to discharge of contract by lapse of times. We can know lapse of time is a period of time that passes, or the reason for a legal agreement ending because an agreed time limit has passed. According to the Limitation Act 1963, it is specified that if the contract is unable to perform within the specified period, it may affect the other party and leads to the cancellation of the entire contract. Then it is treated as a discharge of contract by lapse of times. Like for example, if the promisor fails to perform and the promisee fails to take action within the specific period, then the latter cannot seek remedy through law. It discharges the contract due to the lapse of time. For example, Peter takes a loan from John and agrees to pay installments every month for the next 5 years.
Assalamualaikum. My name is Emir Rashdan bin Zulkifli. Today I will talk about or present about discharge of contract by the impossibility of performance. Okay, so the discharge of contract occurs when there is no interaction within both parties. Even though everything good at the point, then sometimes there must be some problem, some underestimate, unfortunate incident, and etc. So in section 59, it's clearly explained that if any reason may lead to impossibility of performance, then it is advised to breach the contract. Okay, next. So next, we will talk about discharge of contract by accord and satisfaction. Accord is an executor contract that helps to perform the existing duties at the present to avoid the discharge of contract. On the other hand, based on the performance of accord and satisfaction of a contract will be considered and doesn't want to void the entire contract. This means like if you do not satisfied with this contract, you can void it. You can void the entire contract. Okay, next.
So next I will present about discharge of contract by breach of contract. Breach of contract refers to the termination of the original contract due to the failure of performing obligations by either of the parties, which discourage and affect the other party. It relates to void or terminates the original contract completely. This breach of contract may be either anticipatory or actually. So there are three forms of breach, which is refuse to perform, disable himself from performing promise, and repudiate liability under contract. So next, effect of breach. An innocent party may put an end to the contract and must restore any benefit which he may receive from the other party. Section 65 of Contract Act 1950. Next is discharge of contract by the operation of law. If a contract is to be issued by operation of law, it means a change in daily activities leads to the breach of contract. It is majorly observed in corporation. We have three different reasons to discharge the contract by the operation of law. They are by alteration of a written document which fails to perform the obligations in the specific time. By merging, the company happens when a big company equals or take over the existing company, and due to insolvency means the lack of financial capital leads to the bankruptcy, which results in a discharge of a contract.
Assalamualaikum warahmatullahi wabarakatuh. So now me and my teammate will present about the remedies for the breach of contract, and I will present and explain the first one, which is damage. Definition of damage: the court estimated compensation in money or for detriment or injury sustained by the plaintiff in contract or tort. Section 74 Company Act 1950. An injured party is entitled to natural damage and special damage. So natural damage is damage arising naturally and directly out of breach in the usual course of things. Special damage: these damage are those which are indirect result of an injury. Special damage are also can be called consequential damage. They are out of pocket costs directly resulting from a breach of contract. Special damage can be include medical bills, repairs, and many more. The aim of rewarding damage is to give relief to the innocent party for the losses incurred, not to punish the party who is in breach. The last one is damage of unspecified amount. There are three, which is substantial, nominal, and exemplary. We will start off with the first one, which is substantial. A reward given is to put plaintiff in place that he should if defendant perform the contractual obligation. Second one is nominal. A small reward to plaintiff after she shows that there is a breach of contract, even though there is no real losses incurred. And the last one is exemplary. A reward given is far higher than the losses incurred. Thank you very much.
So next, I will present about contumely. Contumely is a claim that can be made by the plaintiff who has performed obligation under a contract and then choose to resign the contract after defendant breach. Court will order a value which is adequate. For the example, in construction contract, additional expenses by the contractor due to a significant change in the quantity of the work which was supposed to be carried out and paid accordingly.
Okay, so for the third remedies of breach of contract is there is specific performance. It is a decree or the court directing that the contract shall be performed specifically according to its term. In the Section 11 of Specific Relief Act 1950, specific performance may be granted by the court in the following circumstances. Okay, 1. The contractual obligation is a trust. 2. Actual damage cannot be ascertained. 3. A breach cannot be adequately relieved by compensation of money. Okay, that's all for the specific performance.
Now I will explain about injunction. For the definition, a decree by the court ordering a person not to do certain act. It is an equitable remedy given at the discretion of the court. Specific Relief Act 1950, injunction is remedy classes in Part 3 as the preventive relief. Preventive relief this means the relief where a party to the contract is prevented from doing particular act which he is under an obligation not to do. Preventive relief is granted at the discretion of the court by injunction, temporary or perpetual, in Section 50 of Specific Relief Act 1950. Temporary injunction. Temporary injunctions are such as to continue until a specific time or until the further order of the court. They may be granted at any period of a suit and are regulated by the law relating to civil procedure. And last, perpetual injunction. A perpetual injunction can only be granted by the decree made at the hearing and open the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. That's all for us. Thank you for watching. Assalamualaikum. Bye bye.